Good morning.
Good morning, sir. How are you?
Doing well. How are you doing this morning?
I'm good, thank you. So far you're the only one here. So as soon as Mr. Allen comes in, do you need a breakout room with him?
I don't think so, to be honest. We had a pre-trial before and he wasn't interested in trying to come to a resolution of this case. So,
Okay, all right. I'll let the judge know when he gets here that you're ready.
okay, thank you.
Thank you. Morning, Mr. Katz. How are you?
Good morning. How are you?
I'm fine, thank you. What case are you here for this morning?
The name of the case is, give me one moment here. I am standing in for Gary Strauss, who is, has
Oh,
a
okay.
chronic, he has a chronic illness, and he
Uh-oh.
called me, it's a Synchrony Bank against Glenn Jackson.
Okay, got it. Okay. Do you need to speak with opposing counsel when they arrive, or are you ready to go?
Well, I'm ready to go. On the other hand, because I'm just handling this hearing today, I have been given some instructions regarding the status of the negotiations. So I'd be more than happy to talk to opposing counsel if it is helpful to resolving the case.
Okay, all right, thank you. I see Mr. Andrew Katz is coming in under the same, I think it's the same case. Are you working together on it?
Who's
Or-
the other individual? What's the
It
name
looks
of the
like,
other?
Mr. Katz, can you hear me?
Yes, I
Hi, good morning. I'm sorry, not Lawrence, Andrew.
can.
Oh,
Yes.
What case are you here for?
I am here on Synchrony Bank versus Jackson Glen.
Are you here for Synchrony?
I'm here for Synchrony.
Oh, okay, perfect. The opposing counsel is here. I'm gonna put you in a breakout room together, okay?
Okay, thank you.
Thank you.
Good morning.
Morning.
And who am I speaking with? My name is Lawrence Katz. Who am I speaking with?
That's fine. They both have the similar last names. They're both here for the attorney of record. Lawrence Katz is here for Gary Strauss, who has a
Mr. Biggleman.
Morning.
Good morning, sir. For reasons that are not clear to me, after you were last here with Mr. Kennedy, the file was never sent to Judge Green to set the in-house mediation. When Mr. Kennedy jumps on, Judge Green is aware that the mediation needs to be set, and that's still how the parties wish to proceed. She is on her Zoom and can schedule something with you and Mr. Kennedy this morning, not to be heard this morning, but to schedule your mediation date, unless you want to proceed with today's pretrial with me.
No, we would just like to participate in the Zoom that the court recommended.
I can't hear you, sir. I'm sorry.
Sorry. The mediation.
Okay. When he jumps on, I'll get you over to her. Marianne, if you would just confirm that she has her Zoom up, she says she would have it ready at 9.
Yes.
Thank you, ma'am. And here is Mr. Kennedy. Mr. Kennedy,
Yes,
I was just saying to Mr. Biggleman that after you were last here, your file was supposed to be sent to Judge Green to schedule your in-house mediation, and for some reason that was not done. Judge Green is
Okay.
she's aware of the issue. She is on her Zoom, ready to meet with you and Mr. Biggleman to schedule a mediation date.
okay.
If you have a pen, I can give you her Zoom number.
Give me 1 second. I know I have one floating around. I'm dropping my son off at school. I apologize.
Don't apologize. Keep being the best chauffeur in the world.
I'm not driving right now. I'm thankfully. We stopped at Park. Okay,
Her Zoom is 933-057.
Okay.
8570.
okay.
She's waiting for you now. Thank you for your patience. This final pretrial and motion date with me will be adjourned out another 90 days to allow you time to meet with Judge Green and maybe get the matter resolved.
Okay, that sounds good.
so
Thank you,
very
Your Honor.
much. You
Thank
both
you,
have
Your
a good day. Thank you.
Bye.
This is 223769GC. This is Portfolio Recovery versus Curtis Allen. May I have your appearances, please?
Good morning, Your Honor. Mike Olson, here on behalf of the plaintiff.
Good morning, Curtis Allen, defendant.
Good morning. Today is the day and time set for the plaintiff's motion for summary disposition. Mr. Allen, you received a copy of this motion?
I did.
Did you file any response, sir?
I did.
When did you file it, sir?
I'm unsure of the date, but it was before our initial meeting, so it would have been in October.
No, sir. This, Mr. Olsey's firm filed its motion on October the 6th.
I completed a response to this.
Mr. Olsey, did you receive a copy, a response to your motion from the defendant?
Your Honor, I don't have a copy in our file.
Mr. Allen, this court doesn't have a copy. The plaintiff's attorney doesn't have a copy. And you said you mailed it before our first appearance.
Correct. I sent a copy to both the court as well as the
Do you have a copy of what you're referring to, Mr. Allen?
sure I do.
Do you have it with you right there, sir?
It would be in my computer. I would have to look it up.
Would you look it up, please? I want to make sure that we are not referring to the answer that you filed with the court.
That is what I'm referring to.
Okay, no, sir. What I'm saying is that after that, the plaintiff's office filed a motion. They filed a motion for summary disposition. And when you were here, the other attorney was Mr. Barta on behalf of the plaintiff's office. That would have been when we appeared on November 1st. On November 1st, I would have indicated that the pretrial and the motion for summary hearing was adjourned to this morning. Mr. Olsey, present your motion, please.
Okay, good morning, Your Honor. This is a plaintiff's motion for summary disposition pursuant to C9 and C10. This is in a collection matter for which a defendant entered a contract with plaintiff's assigner, Capital One, on July 22nd, 2014, with the extension of line of credit with the promise to pay. Prior to December 8th, 2017, defendant breached a contract for failing to submit payment that was ultimately charged off. The account was then sold to our client plaintiff on April 13th, 2020. And again, in regards to the account stated, MCL 600.2145 states that, again, in order to contest this motion, that the plaintiff has to, again, attach an affidavit in regards to disputing the debt. This has not been done. Also, in regards to the answer, plaintiff again stated that they do not recognize this debt. However, again, our client sent an investigated the matter to confirm whether or not he actually was the person that opened this line of credit. That was confirmed. In regards to the allegations that, again, he lived in the city of Romulus, multiple of the charges for, again, which this credit was extended to, pertain to charges in Romulus, specifically as attached to the motion. Some of the charge-off statements indicate that on September 27th, there were charges done in a Shell gas station in Romulus. In August 2017, there was charges done at a Taco Bell in Romulus, and again at a Shell Oil gas station. In July of 2017, again, there's another Shell Oil charge in Romulus. And in June of 17, again, there's 2 different charges at a Shell Oil gas station in Romulus, Michigan. We have attached an affidavit confirming the fact that this is the amount that is owed. And there's no dispute that, again, that this credit would be owed to our client.
Anything else, sir?
Oh, and this, in the amount that's outstanding would be, including of costs, would be $2,207 and 49 cents.
Mr. Allen, your response, sir?
So when we came to court on November 1st, one of the first things that I noticed about the motion that was filed was that, like it was stated, these were at an address that I didn't live at. I've been in Romulus since 2016. There are plenty of purchases on there that are in different cities, especially Southfield, which is consistent with the statements. I don't see how that's really relevant. I came to court and met in a break room with the previous attorney that was here. It was immediately clear that he did not know my social, he did not know my date of birth. He admitted that sometimes they do get the wrong person in these cases. He did not file the motion within the guidelines. It's just a myriad of mistakes that have been made. And I've mentioned in the previous motion, in the previous hearing that I would have been able to confirm whether or not any of this belonged to me just by looking at the contract. In the motion that was filed, it references the contract with Capital One 9 times, yet it's failed it was not provided within Exhibit 1 as it was referenced. In a contract, if there was an agreement with me and Capital One, my signature would be on that agreement. There would be mention of an agreement to repay. None of this could be proven. There's no evidence here that we even have enough to move forward on without being able to look at that contract.
Anything else, Mr. Allen?
No, ma'am.
Anything
Yes,
else, Mr.
one more thing. The original amount that I was looking at said $2,065. He's now given a different amount that I've not seen or been aware of. So there's more inconsistency there.
Again, just to address those, again, in response to defendant's argument in regards to the amount outstanding, yes, the amount of $2,065.43 that was outstanding for the amount demanded at the end of my argument. That also included the costs incurred for having to pursue this, which was in $142.06, making a total judgment to be $2,207.49. That's laid out in the proposed judgment attached to the motion to our exhibit. In regards to the argument in regards to the contract for an account stated, that's not needed for approving a motion for summary disposition. In order to have an action for account stated, it's plainly simple that there's an agreement to pay and that there's an account that becomes outstanding, and the failure to ultimately to object within a reasonable time to amount of payments constitutes omission for the amount of its correctness that is owed. Yeah, we have an affidavit from our client stating again this account was a purchase, that Mr. Allen is the person that's owed this debt. The amount that's owed is not in dispute. And again, but the fact that again the defendant failed to file any sort of response to this motion at all, and they are subject to the same court rules as any other party, whether represented or not. And based on there's no material fact that the judgment should be granted for our PRA.
Thank you.
My response.
Mr. Olses and Mr. Allen, the court had reviewed the file in its entirety, including all of the attachments to the plaintiff's motion. Mr. Allen, when we were here back on November 1st, 2022, this court would have advised you that you needed to respond in writing to the motion for summary disposition. You did not do that. Based on that, this court has to take the motion as it is with the statements attached thereto. Based on that, the court will grant the plaintiff's motion for summary disposition. There was a proposed order in the file granting that motion. The court has signed that, and copies will be mailed to the parties at the addresses as they appear in the file. Anything else, Mr. Olses?
No, Your Honor.
Anything else, Mr. Allen?
I would just ask that, so there's with Capital One, according to my research, there's in any contract, there's an allowance for mediation. I would ask that that contract be reviewed and that mediation allowance be proceeded on.
Mr. Allen, the court has already granted the plaintiff's motion for judgment. We are beyond that stage in the proceeding, sir. A copy of the order will be mailed to you. Mr. Olses, please take my greetings to the other Mr. Olses, please. Have a good day.
Thank you.
Thank you.
Have a good day as well.
This is 220503 GC. This is Beaumont Health versus Tiffany Fleeson.
Morning, Your Honor. John Vanchuk on behalf of the defendant.
Mr. Burke is trying to pop in. I've seen him a couple of times
Yeah.
this morning. I did not think I would see you. I was expecting a
Yeah.
consent judgment from you too.
That was my fault. My client signed it back in early November and I forgot to send it to Mr. Burke and I figured it out yesterday afternoon.
Mr. Burke, I just called the case and indicated to Mr. Vanchuk that I was none too happy that there was not a consent judgment.
I can't hear anything. I can't hear anything. Can anybody hear me?
Yes.
Yes, sir, I can
I
hear you.
apologize, Your Honor. I cannot, some reason I can't hear, but I will say that I believe this case is resolved. And John, could you shake your head if you sent me the side consent?
I did.
Your Honor, could you give me until the end of the day to get this to you? I do have Miss O'Reilly's email at your 36th district. I'll send it, email it to you if that's okay.
Thank you. Please get that consent judgment over. If it's not here by
We
Friday,
got
I'm
it, yes,
setting a
we got
trial
it
date.
yesterday from John Eventus.
Yeah, that was my fault, Your Honor, not Mr. Burke's.
Anything else, Mr.
I
Vanchuk?
apologize, but I will
Um,
email it today.
No, no, Your Honor, nothing further.
Thank you.
You both have a good day.
Thank you.
This is 222032 GC. This is Synchrony Bank versus Glenn Jackson. May I have your appearances, please?
Good morning, Your Honor. Andrew Cates, P78292, standing in for the attorney of record David Canine and representing Synchrony Bank.
And Your Honor, I am Lawrence Katz. I'm standing in for the defense counsel, Gary Strauss, who is ill, on behalf of the defendant, Glenn Jackson.
Thank you. The parties had an opportunity to speak this morning. Today was the pretrial in this matter. Mr. Cates, how are we proceeding?
We're proceeding based on the fact that we think that this case is already pretty close to being settled. There's already been some back and forth between the counsels of record. We just asked for a scheduling order to be entered and perhaps like another 60 and 90 days worth of discovery so that we can get this matter resolved for you off your
Mr. Cates,
docket.
the plaintiff's attorney of record may not have accurately relayed to you the status of this case. There's already been 60 days of discovery. Today was the final pretrial motion hearing date in this matter.
Oh,
So if you're close to being settled, what this court can do is give you a trial date. Maybe that will prompt you to move towards settlement a little quicker. Give me
that
one
would be
moment.
fine, Your Honor.
Let me grab a calendar. Hold on. Bench trial date, January 3rd, 2023 at 11 a.m. by Zoom unless either party wishes to appear in person.
Thank you, Your Honor.
Thank you, Your Honor.
Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor.
If you resolve this matter before that trial date, you may email your settlement document to the civil department. Have a good day, gentlemen.
Thank you, you too.
Thank you, Your Honor.
This is 093062 GC. This is Midland Funding versus Maisha Edwards.
Yes, Your Honor.
Good morning, Your
May I have
Honor.
your appearances, please?
Good morning, Your Honor. Mimi Kalish, appearing on behalf of Midland Funding. My P number is 52383.
Ms. Edwards,
Good morning, Your Honor.
state your name for me, please, ma'am.
Maisha Edwards.
Thank you. Today is the day and time set for hearing on the plaintiff's motion to set aside the order for installment payments. Ms. Edwards, you received a copy of the plaintiff's motion wherein they indicate that you have not made a payment on the installment payment order.
Yes, ma'am.
You have a response to that, ma'am?
I have made payments. I bought a home earlier this year in February, and I just fell behind on all of my bills. So my apologies.
How far behind is she on the payment plan, Ms. Kalish?
Your Honor, the order for installment payments was entered on September 20th, 2021. She made one payment on November 18th, 2021, no payments in December 2021. In January 20th, 2022, she made a $200 payment, presumably to make up for the December 2021 payment. No payment in February. March 31, 2022, she made a $200 payment, presumably to catch up for the missed payment in February 2022. Then no payments were received until July 27, 2022. That was also in the amount of $200, and no payments have been received since July 2022.
Ms. Edwards?
Yes, I have my bank statement showing that I have made a payment since July. So yes, I did miss a couple payments, and then I would try to make up with the double payment. But yes, I have made a payment since July.
Ma'am, you have proof of that? Are you
I have-
current on your payments, I guess is the real question.
I know I haven't been current. The last payment that I made was in September, I believe. Which is I have that September bank statement. But once I received the notification in the mail stating that the set aside in the hearing, I didn't make another payment since then because I wasn't sure exactly how that played into the payment plan.
We don't
Anything
have
else, Ms. Kalish?
nothing further, Your Honor, other than the last payment this office received was July 27th, 2022, and the current balance remaining on the judgment today is $5,915.23.
Thank you. The motion previously filed by plaintiff's office does in fact indicate that the last payment in this matter was on July 27, 2022. Ms. Edwards, neither the response that you filed with the court on March 9th nor your testimony this morning suggests that you have brought these payments current. Based on that, this court is required to set aside the September 2021 order for installment payments. There is an order in the file. The court is signing that. Plaintiff may proceed with other collection activities. Anything else in this matter, Ms. Kalish?
Nothing further for plaintiff. Thank you, Your Honor.
Anything else, Ms. Edwards?
I can't afford to have my paychecks garnished, ma'am. I'm not purposely trying not to make them. I literally just had someone else garnishing my paycheck. I cannot afford it. I'm not purposely trying to not pay them. I'm doing the very best that I can.
Ms. Edwards, I understand that, and that's why when the order for installment payments entered last September, I typically tell people, if you can't make the whole payment, make some payment, because plaintiffs would rather you try, because it's easier to catch up if you've only have a partial, if you miss a partial payment versus missing months and months of payments. So it's not that
Understood.
I'm not sensitive to your situation. It's just that plaintiff has not received a payment since July. I can't deny their request. So it's been granted. I've signed the order. It will be mailed to the parties at the addresses that we have in the court file.
May
I
I
can't-
confirm? May I confirm the defendant's address? I understand I guess it's the address on the answer that she filed, which is 28427 Forestdale in Romulus. Is that correct?
That is the correct address.
Thank you.
That concludes this matter. Have a good
Thank you,
day.
Your Honor.
Is there anything I can do?
Edwards, the court can't give you legal advice,
I'm not,
but you
I'm
can
not,
reach out to,
I'm sorry, Your Honor.
no, go ahead.
I was just simply saying, I can't not get paid. I'm barely paying my mortgage as it is. So I can still pay them, but I can't afford the $200. I can't.
The installment payment order was $100 a month.
I can't afford that either, ma'am. If I already have someone garnishing my paycheck and now you're trying to garnish my paycheck, that leaves me with actually nothing. I'm a single parent of 2 daughters. I get no child support. I am doing the best that I can.
Ms. Edwards, your paycheck can only be garnished by one creditor at a time.
Exactly, ma'am. But I don't know if they're seeking collections and I already have that garnishing my paycheck, then that means as soon as that garnishment's complete, another one kicks in. I just don't understand. I'm trying to make it right, but I don't know what to do here.
Ms. Edwards, you can call legal services, or you can go online to Michigan Legal Help, and you can get some information regarding possible ways to proceed in this matter. I just can't give you legal advice,
Okay,
but those are resources that are available to you, okay?
okay.
Thank you, ma'am. Have a
Thank
good
you.
day.
Thank you, Your Honor. Good luck, Ms. Edwards.
This is 221840 GC. This is Citibank versus Julie Loren. Can I have your appearance, please?
Good morning, Your Honor. Brian Gruen, GROEN, PN number is 56673 on behalf of plaintiff Citibank.
Thank you. I have not seen the plaintiff yet. I'm sorry, the defendant yet this morning. This case was scheduled at 9:15. This court's policy is 15 minutes after the scheduled start time. We're not quite there, but pretty close. The last time the parties were here on September 6th, there was a consent judgment pending. This court has not received anything in the interim. What's the status of this matter, sir?
Your Honor, we also appeared at a show cause in, it looks like in October with the magistrate. And as I explained to her, the defendant's working with a debt settlement company. Payments are being made and are current. We originally sent the original consent judgment to the debt settlement company. That was never returned. So after the show cause hearing in October, I mailed a copy directly to defendant. That also has not been returned. So I'm not for sure if the court is willing for me to place the terms of the settlement on the record. I could submit a proposed consent judgment under the 7-day and give the defendant an opportunity to object, or I'll just have to proceed with our motion and take it from there.
I would suggest that you proceed with your motion, which the court has reviewed in its entirety.
I will do that, Your Honor. Then just within the judgment for our motion, I'll set forth the terms of the settlement as well. Your Honor, this is our motion for summary disposition based on MCR 116C 9 and 10, whereby defendants failed to state a valid defense and also there are no genuine issues of material fact for trial. This case pertains to an unpaid Best Buy Visa card that was opened in August of 2018. The last payment was received in July of 2019. The account was charged off on February the 7th of 2020 for the amount cited in our complaint of $3,840.52. As I've indicated to the court, the defendant is working with a debt settlement company. Payments have been made, totaling $1,122. So the remaining damages as of today's date is $2,718.52. We have incurred costs of $139.70. So we are seeking a total judgment in the amount of $2,858.22. I'll just note to the court that the defendant has not filed any type of response to our motion. So she also is not here on the hearing date.
Thank you. Today being the day and time set for hearing on the plaintiff's motion for summary disposition, defendant having failed to appear this morning, she failed to appear previously and did not file a response to the motion. Plaintiff's motion will be granted. There was not a proposed judgment attached to your file, sir. If you want to submit one to the court civil department by email, they'll send it up to me for signature, okay?
Can someone chat me the email address to send that to, Your Honor?
Absolutely, sir.
I appreciate it. Thank you so much.
Thank you. This is 223829 SC. This is Big Steve's Design versus Ulysses Merriweather. May I have your appearances, please?
Ulysses is here.
Steve is here.
Mr. Merriweather, before we proceed, I want to disclose to you that I am acquainted with Mr. Harmon by virtue of the location of his establishment. We have never been to each other's homes. We've never shared a meal together, but by virtue, again, of him having a business located across from the court, I am aware of him and have an acquaintanceship with him. Knowing that, sir, do you still wish to proceed in this matter?
Yes.
Mr. Merriweather, raise your right hand for me, sir. Do you swear from testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Today is the day and time set for hearing on your motion for installment payments. On that motion, sir, you list a number of expenses, but you do not provide any income.
Yeah, because I
source?
don't have any income right now because I'm recovering from a stroke that I had in July of this year. So I'm not working whatsoever, and I'm waiting on the state to actually go through with my paperwork for me to get paid some money from the state. And before that, I was laid off from work because of the auto industry when they went down to a 1 shift where it was a 3-shift facility. So I no longer had a job. But I'd like to include something with this today, can I?
Yes, sir.
Hello? Okay. Steve was visited by Agent Corey Solomon from the investigation services of the state of Michigan. He told Steve that he needed a license to operate operate his shop. Steve does not have a license. I had somebody from the state verify that. They came back with the law, MCL 257.1331, says that Steve needs to pay back all the money that I have given him because he's not licensed to do any work whatsoever. And I need to take him to court for that. So all the money that I gave to Steve, he needs to pay back. And I'm sitting with a motorcycle in my garage that doesn't work. And it was a brand new motorcycle.
Mr. Merriweather, I reviewed your motion and I didn't see that information included anywhere.
This
with your
just came
filing.
to,
Is this something?
this just came to my attention late last week. He just called me back on it. and he gave me the law number on it and to take it to my attorney because Steve's going down to the courthouse downtown. I was just waiting to get all the information in hand. And because I had already told him that, there's a lawsuit that's going to be going against him for this bike because this bike cost me over $30,000. I'm not arguing with the money that he charged. I paid Steve up front for the services. He did not provide the services like he said, and he changed motorcycle parts on my bike out for used parts. And I do have complete evidence that he did this.
Mr. Merriweather, you pursuing a claim against Mr. Harmon in another court is another conversation for that court on another day. What was before this court this morning was your motion for installment payments. Mr. Harmon did file a response that requested a different, requested a creditor's exam essentially. Based on the comments you made, are you withdrawing your request for a payment plan in this matter?
Yes, for the simple fact that any money that I gave to Steve, he has to give back to me for the simple fact, according to that law 257.1331, he has to pay me back because he has an unregistered facility doing business.
Okay, Mr. Merriweather, you understand what I'm saying regarding the fact that that's something that you have to pursue in another court, your claim against him.
Yes, but the claim is
Okay.
still, okay, I understand that.
Go ahead, finish what you were saying, sir.
Okay, but I was saying that all this is actually like the same case. And if, I believe it needs to be delayed until the truth comes out and Steve see the damages that he has done. And we go to the court with it. And if I owe Steve some money, I will gladly pay Steve his money. Because I've never once told Steve I didn't have his money when it came time to pay him. I gave Steve money up front back in 2020 to do this bill. I never once told Steve I wasn't giving him any money until we got to the end of the process of the bill when he was lying about certain things. And I had the facts to prove that he was lying about them.
Anything else, Mr. Merriweather?
No.
Any comment, Mr. Harmon?
Yes, ma'am. Like I said, I took Mr. Merriweather to court because he failed to pay me the labor bill for the motorcycle. Mr. Merriweather is going off of a statement I made to him. I did tell him that I would look out and discount the labor. The labor on the motorcycle exceeded $10,000. All I was asking for was $6,500 because it took so long because of COVID and because of COVID, and it just took me a long time to get the parts. When I was finally finished with the motorcycle, and even in the court record, he said that I only told him that I was only going to charge him $800 for doing the lights on a huge build on that motorcycle. I did nothing mechanical to Mr. Ulysses' bike. Everything was cosmetic. At the time, I had two people working for me. Jeremy Harvey is a licensed mechanic. He was killed on his motorcycle back in September. So he is a licensed master motorcycle mechanic. Now I have a Milton Baltzer working for me, which is a licensed master motorcycle mechanic. So what he did in turn, I had another guy working for me named Trey Sapp, who Mr. Merriweather talks to often. And Trey's been giving him false information because I let him go for various reasons. But at the end of the day, Mr. Merriweather, it was a judgment for $5,000 by Judge Oakley. He put in a request for, what is it called? I forget the request for monthly payments. And like I said, he was ironic is when I started working on Mr. Merriweather's bike, I was working out of my home, out of my garage. So now all of a sudden he has to pay this money. Now he's doing any and everything he can not to pay me my money. He's running to the state. The state came in. Yes, they did. They seen the mechanic's license in view that I do have a licensed mechanic. I got some other paperwork I need to take care of. Yes, but it is in the process. The agent did call me and tell me he was dropping the case, and that was it. He was dropping the case. But even though he did make a motion for installment payments, he still hasn't made the first payment because why? And $100 a month, I'm supposed to wait 60 months or 50, well, however it is, to get $5,000, $100 a month, when he definitely, if he can walk into my house with thousands and thousands of dollars. I know him personally. He wasn't laid off, and he had that stroke. Yes, he did have a stroke. That's not no fault of my own. But all I know is he's coming to my shop. He's made threats, physical threats. He's threatened to burn. I feel like burning your house down. He know where I live. I know where he live. I didn't want this to get out of hand. All I want is what's owed to me, which was I asked for half of the labor bill, and he doesn't even want to pay that.
Anything else, sir?
No.
Anything else, Mr. Merriweather?
Yes, Steve's totally still not telling the truth on the whole ordeal, but we took that up in court already. All I'm here to saying is there's a law stating 257-1331, and Mr. Agent Corey Solomon made it real clear to me that you have to have a license, and if you had somebody working with you that time, I need you to show proof of it, because I'm sure he was on your payroll. Let the court know where you was paying him from and go from there. But since he's not allowed right now to testify, that I'm sorry to hear for your loss.
Mr. Merriweather and Mr. Harmon, here's the thing. There was a judgment entered in this case on September 29, 2022. There are certain avenues of collection that is allowable in civil cases. The defendant filed a motion for installment payments, and that is all that is before the court this morning. I understand there are some other relationship issues or some other claims that might need to be worked out by the parties or between the parties. But Mr. Merriweather, this court's inclination is to grant the motion for installment payments at the rate you requested. If it's your desire to abandon or withdraw this motion for payments because of these other issues, then I'll deny the motion and the parties can proceed either in this case with some other collections or through the other case that you referenced that you have an attorney for. So my question to you specifically, Mr. Merriweather, is how do you wish to proceed this morning?
I want to delay the case and have it all taken care of together. And if it says the court
It's not,
said
Mr. Merriweather, just be clear. There is a judgment in this case.
okay, I want to go against the part that you said where I can actually not pay right now because I don't feel that I owe Steve any money.
Okay, Mr. Merriweather, if you wish to abandon your motion, the court will make an indication in the file that you have withdrawn your motion for payments. Please understand that that does not stop Mr. Harmon from making efforts to collect on his judgment. It just means that there's no order for installment payments.
Okay, and what's going to happen after if I abandon it?
I don't know. I don't know what
What I'm
Mr.
saying, will
Harmon's
Steve
intentions.
be still able to come after me for payments, even though I have a case coming up for him that he's going to get the paperwork on real soon?
Yes, sir, because those are two different cases. And that's why I started after Mr. Harmon said what he said, and I asked you, do you have anything else? I said to you, this is only about the September 2022 judgment. Any other issues you all have, whether it's through the state licensing or some other case that your attorney files regarding some other claim that you have against Mr. Harmon, that's a separate issue for a separate day. Before this court this morning is, there's a judgment from September. More than 30 days have passed and Mr. Harmon has not been paid in full. You're asking the court, your motion asks the court to protect your wages from garnishment by entry of an order for installment payment.
Okay, I see what you're
So that's
saying.
why I'm saying,
Okay, I got you. All right, so I want to go against that. I want to say that go ahead and grant Steve the $5,000, but I can't pay Steve right now. I have no income coming in.
Mr. Merriweather, you're not listening to me. There is a judgment for $5,000. That judgment is already entered by Judge Oakley.
In the
That
system.
judgment's final. My question to you is, do you want the court to enter an order this morning for $100 per month?
Yes,
Or when are you gonna make your first payment, sir?
I can make my first payment the third week of this month.
The third week of this month, 1, 2, 3 is sometime on the week of the 19th.
Yes.
What day of the week, sir?
Say the 19th, like 20th. go with the 20th.
20th is a Tuesday, and then it'll be the 20th of the month thereafter.
That's fine.
December 20th, 2022, $100 must be paid to the plaintiff. Made payable to Big Steve's Designs and mailed to them at the address as it appears on this court's file. Anything else?
No.
Anything else, Mr. Harmon?
Yes, only thing I have to say is from the beginning, even after he lost the judgment, he left me this real sarcastic voicemail. When you want me to come pay you your money since you feel so uncomfortable. And he said that because all the threats were made. And, you know, like I said, the only reason I gave him that motorcycle back, and he knows it, because he threatened physical harm to me. And he did make the, you know, like I said, telling me he wanted to burn my house down. But I just want to get paid. And I shouldn't have to, $100 a month is not sufficient.
Anything else, Mr. Merriweather?
No.
Thank you. The court has signed the order. Copies will be mailed to the parties at their addresses as they appear in the court's file. Thank you. You both have a wonderful afternoon.
All right, you also.
Thank
Bye.
you. Mary